Ever sign a contract and kind of think, what if this all goes sideways?
Right.
Well, today we're tackling breach of contract.
Getting into the weeds.
Exactly. You've sent in some legal docs, so we're making this deep dive work for you. We'll lay out exactly what makes a breach, officially a breach, and what you can do if you're facing one.
And you might be surprised, it's not always about just like completely bailing on the whole agreement. Sometimes, even if it seems like a small thing, like you deviated a little from what you promised, that can actually be a problem, legally speaking.
See, now that's interesting. In my head, a breach is like someone throws their hands up, nope, not making that widget, contract's off. But are we saying, like, even a late delivery could be a problem?
Exactly. Each little detail, each promise in that contract, it all builds up expectations, right?
Okay.
Anytime you deviate from what you promised, no matter how small it seems, it could be considered a breach. The legal term is deviation from promised performance, which I think highlights that even a small departure can have consequences.
So it's not just, I'm tearing up this whole contract.
Yeah.
It's even that tiny promise you broke. Yeah, we could come after you for that.
Yes.
Okay.
Precisely. Think of it like this. Let's say there's a contract, right?
Yeah.
And it says, delivery date for these construction materials this date, gotta be there.
Okay.
Even one day late, if time was super important in that contract,
Right.
that could be a breach.
That makes sense. But then how do you differentiate? Because a one-day delay on materials versus a contractor who's supposed to, finish a whole addition on your house and they never finish a room.
Right.
Those don't carry the same weight.
You're right. They are not all created equal. So a one-day delay, that might be a minor breach.
Okay.
But the unfinished room, that's what we call a material breach. That's a much bigger deal.
So a material breach is like the VIP of contract violation.
Exactly.
What makes it material, though, legally speaking?
A material breach is when you deviate so much that it basically undermines the whole point of the contract in the first place.
Wow.
It's not just like a little hiccup along the way. It's like the whole operation is messed up.
Right.
So going back to the contractor, if they don't build an important part of the house, that's a material breach. The homeowner is not getting what they signed up for.
So in that situation, the homeowner would have more options than to be like, hey, you're late. Like, what can you actually do if you're on the receiving end of a material breach?
Well, they might be able to completely terminate the contract.
Oh, wow.
And then sue for damages because essentially the other party, they didn't hold up their end of the bargain. So you're off the hook for yours.
Interesting.
It's about making it fair.
Right. So it's not just about me getting what I was promised, but it's like I shouldn't be penalized because you couldn't keep your promise.
Exactly.
Interesting. Okay.
Now, let's say a company says, we are not delivering these goods, even though they agreed to. That's what we call repudiation of the contract. Like, we're not doing this.
That one seems more straightforward. Like, I'm not doing the thing I said I'd do. That's a breach, right?
Yes.
But what's interesting is there's a way to walk that back.
Yes, there is.
It's like the undo button on the breach.
You're talking about retraction, right?
Yes.
So if someone says, I'm out, basically they have a little bit of time to say, just kidding, we're back on.
Oh, interesting.
But it's a limited window. Think of it like hitting pause, not rewind.
So there's hope, even if it seems like the contract's dead.
There can be.
That's good to know. But what if you sense a breach coming? Even if technically the other side hasn't done anything wrong yet, but you see these red flags, you're like, uh-oh, I don't know if they're going to be able to actually do this. Can you do anything then?
Yeah, that's where adequate assurance comes in.
Okay.
If you have a reason to be worried, a good, solid reason,
Right.
you can actually demand reassurance from the other side.
So you're like, hey, are we good here? Because I'm a little freaked out.
Yeah.
What counts as adequate, though? Can I just take their word for it?
It's got to be convincing, right?
Yes.
Like a flimsy promise, that's not going to cut it.
Okay.
And here's a key detail. Under the Uniform Commercial Code, or UCC,
Oh, yeah, the UCC.
governs lots of business transactions. This demand for reassurance has to be in writing.
Oh, really?
No casual texts. Hey, by the way.
You good?
No, it's got to be official.
So putting it in writing is like, it just makes it real, like the contract itself was.
Exactly.
Okay, so you've got that paper trail going. But what happens when, despite your best efforts, the dreaded breach happens? What are your options? Let's get into that.
So when a breach happens, right, the legal system, it often tries to kind of reset things.
Okay.
Put the injured party back in the position they would have been in if everyone had just, like, followed the contract.
Right, right.
And this usually involves something we call damages,
Go.
which is basically, money to make up for the loss.
Okay, so let's talk money. when a contract goes bad, what kind of damages are we talking about? Like, can someone actually try to get?
So one of the most common types is called expectation damages.
Okay.
And the idea is to put you back in the same financial position as if the contract had gone, perfectly.
So, like, if I ordered custom-made furniture,
Yeah.
I paid $5,000, and then the carpenter just disappears,
Right.
vanished. But then I find a really similar set for $6,000.
hmm
Would I be looking at that $1,000 difference as expectation damages?
That's the general idea. We're trying to make you whole again financially.
Gotcha.
But sometimes it's not just about, the price difference of finding a replacement.
Okay.
Sometimes you've made other expenses, based on the contract actually happened.
Right, right.
That's where we get into reliance damages.
Okay, so in my furniture fiasco, let's say I also paid $500 to have it delivered and like $200 to get rid of my old furniture.
Right.
Would that factor into those reliance damages?
Absolutely. Because those are costs that you wouldn't have had if that contract hadn't happened and then fallen apart.
Right.
So it recognizes that you relied on this agreement and it cost you real money.
Yeah, that makes sense. You've got to consider the ripple effect of a breach. What about those situations where, like, the breaching party, they actually benefit from things going wrong? So, like, they take an upfront payment and then they disappear.
Right. So that's where restitution damages come in.
Okay.
Because it's about preventing what we call unjust enrichment.
Right.
Even if it means, like, the breaching party ends up worse off than they started. It's about taking back those,
Ill-gotten gains.
Yeah, exactly. Ill-gotten gains, yeah.
So if my carpenter took off with, let's say, $1,000 for materials up front, I might be able to get that back as restitution.
Yes, because it's about restoring fairness, making sure no one's, like, unfairly profiting from breaking a promise.
It seems like there's a real theme here of making things right financially.
Yeah.
Are there limits to that? Like, is there a cap on how much someone's on the hook for if they breach a contract?
That's a great question. There's this concept of foreseeability.
Okay.
And this comes from a really famous case, Hadley v. Baxendale.
Okay.
And basically what it says is you can't hold someone responsible for something that nobody could have reasonably predicted.
So I can't sue someone for like $1 million because they forgot the pickles on my sandwich.
Exactly. When you enter a contract, you accept a certain amount of risk.
Right.
But you can't be expected to foresee every single consequence, especially if it's like really remote, not very likely.
Okay, so I hire a taxi to get to the airport.
Yeah.
Taxi breaks down.
Oh, no.
I can probably get the cost of a new ride.
Right.
But if that makes me miss my flight and I miss like $1 million deal.
Right, and that's where it gets tricky. Unless you told that taxi driver very specifically, hey, if I'm late, I'm going to lose $1 million.
Right.
A court would probably say, that's not really foreseeable. They're going to limit what the taxi driver has to pay to those more predictable outcomes.
Right, just the cost of the new taxi.
Exactly.
So it's about drawing those lines, right? Like what's reasonable to expect.
Exactly. It keeps things fair and focuses on the harm that was actually caused by the breach,
Right.
Not some crazy out there thing.
Okay. This is helpful because it sounds like a lot of times these breaches, we're talking about financial compensation. But what about when money doesn't fix it? Like, what if the thing that was breached was, like, irreplaceable?
That's a really important point. Sometimes money isn't enough, and that's where equitable remedies come in.
Okay.
So instead of just money, or maybe in addition to money, a court can order a specific action.
So instead of paying up, they might have to actually do something to right their wrong.
Yes. And a classic example is what's called specific performance.
Okay.
That's where the court says, nope, you're going to do what you said you'd do in the contract.
Wow.
It's not always an option, but it's often used when we're talking about something unique.
Where money just wouldn't really make the injured party whole.
So, okay, my carpenter, if he took my money and the plans for my one-of-a-kind custom chairs, money can't replace those.
Right.
Could a court order him to finish building them?
That's the idea.
Wow.
Because it recognizes that sometimes money isn't enough to make up for a loss.
Wow, okay.
Another equitable remedy is called an injunction.
Okay.
And that's a court order telling a party, you can't do this specific thing.
So, like, I have a contract with a vendor, and we agreed they're not going to sell their stuff near my store.
Right.
And then they open up shop right across the street. Could I try to get an injunction to shut them down?
Yes, exactly. Injunctions are used a lot to prevent, like, further harm or further breach of contract.
Right.
So it's like a legal cease and desist.
So we've got money to cover losses. We've got these equitable remedies to, like, force action or prevent harm. It's like a whole legal toolkit for dealing with this stuff.
Exactly.
Yeah.
It's about options,
Yeah.
and making sure there's a fair outcome, however that happens.
Okay.
But we've been talking a lot about what happens after a breach.
Right.
Let's go back to something you mentioned earlier about those little red flags
Right.
before things really go south.
You mentioned adequate assurance. Like, you can sense something's off, even if nothing's technically gone wrong yet.
Yeah.
Seems powerful, but kind of tricky.
Yeah.
When do you actually have grounds to, like, demand that reassurance? What if you're just, like, being paranoid?
It has to be, reasonable.
Right.
Like, there has to be something real there.
Okay.
So let's say your supplier's constantly late with deliveries.
Okay.
Or their finances are a little shaky. You've heard things.
Yeah, you see some red flags.
Right. Or maybe they announce big layoffs. You're like, uh-oh, I'm expecting a huge shipment from you guys. Those are red flags.
So it's not just a feeling. It's like you've got some evidence that maybe things are shaky.
Exactly.
Wow.
And then how they respond when you ask for that reassurance.
Right.
That's important, too.
Okay.
If they blow you off.
Right. Or they can't give you, like, a solid guarantee.
We got you, don't worry.
Yeah, exactly.
Hey.
That's flimsy. That actually can make the situation worse.
So demanding assurance, it's not just for me to feel better. It's like, legally, that's a smart move.
It can be,
Yeah.
because it puts them on notice.
Like, hey, I'm watching.
We're paying attention.
Right.
And then if something does happen, how they responded to that or didn't respond, that's part of the picture.
It all goes back to, like, just clear communication throughout the whole thing. Even when you think everything's fine with the contract, you've got to keep talking. Right.
Absolutely.
Address those issues head on.
And speaking of communication, you had mentioned a type of breach that I think is really interesting. It's called bad faith hindrance.
Oh, right.
This one's not as obvious as, like a missed payment.
Right. It's sneakier.
Yeah.
It's like, you technically did what you said you would.
Right.
But you made it so hard for me to actually benefit from that.
Exactly. It's like you were trying to get out of it the whole time.
Like, imagine a construction project, right?
Okay.
The subcontractor delivers the materials on time, but they send the wrong materials.
Oh, that's the worst.
On purpose.
Yeah.
Knowing it'll mess the whole thing up.
So frustrating.
Right. Or they delay things just enough to cause a problem, even though technically they met the deadline.
It's like they're playing a game, right?
Yes, exactly.
Like, I didn't technically violate the contract.
You can't get me.
But you're really violating the whole spirit of it.
Right.
Is that really a breach, though, if they did technically do the thing?
It can be. Proving bad faith, it's hard.
Right.
But courts understand that, when you sign a contract, you're supposed to be acting in good faith.
Right. We're all on the same side here.
We're all trying to
make this work.
Make it work. Exactly.
Okay.
So there's this idea that you have to deal fairly with each other.
Right.
Even if there's not. Like that one big thing.
Yeah.
Right. The smoking gun.
Yeah. If you're just like consistently being difficult.
Right.
A pattern of bad behavior.
Gotcha.
That can be a problem.
Wow, so much nuance to this stuff.
There is.
It's not just like, you broke rule 5, you're in trouble.
Exactly.
There's a lot of, like, what did you mean? Were you trying to be sneaky?
Yeah, it's about the spirit of the agreement, not just the words on the page.
It's like the vibes matter.
They do.
The contract vibes.
The contract vibes matter.
Okay, so that's why it's so important to just, even if you're not a lawyer,
right,
to have this basic understanding.
Yes.
Because then you can, like, protect yourself.
Exactly.
And when you're going into business with someone, you know what you're getting into.
You can spot those red flags.
If
you can make sure the contract's really solid.
We've covered so much.
Yeah.
Those small little deviations.
Yes.
Those big deal-breaking breaches.
Material breaches.
Financial remedies, all those different types.
And the equitable remedies.
Right. Where it's like, more than just money can fix it.
Exactly.
We talked about lost volume sellers. That was wild. You can actually...
Even if you find a new customer...
Right. Amazing.
You might still be able to claim damages.
Adequate assurance. Love that as a tool. When you sense something's off.
Get ahead of it.
Yes.
Don't wait till it blows up.
I think we did it. We equipped our listener to go forth and navigate this crazy world of contracts.
I think we did.
Hopefully they feel a little bit more confident now.
The more you know,
right,
the better off you are.
And knowing is half the battle.
That's right.
On that note, we've reached the end of our deep dive. Listener, we hope this was helpful for you.
Yes, illuminated.
And that you enjoyed this exploration of breach of contract as much as we did.
It's fascinating stuff.
It really is. Until next time.
Take care.
Remember, knowledge is power.